Okay. Good afternoon. Good afternoon. Oh, you guys are a rowdy bunch. No, I'm sorry. I am delighted to welcome you to the Jerome Hall Lecture at the IU Maurer School of Law and the first of our semester-long Brown at 60 series. This year marks the 60th anniversary of the landmark Supreme Court decision in Brown versus Board of Education. As you know, Brown reversed the legal reasoning behind Plessy v. Ferguson, the infamous 1896 ruling that separate but equal was legally just and constitutional, and Brown ushered in a new set of laws that made segregation in our public school system unconstitutional. The Brown case was heralded then, as it is now, as a watershed moment in American history. And throughout this semester, the law school is commemorating the anniversary with a series of lectures, workshops, and film screenings. We're very fortunate that the Brown 60 series is supported by generous funding from the Office of the Vice President for Diversity, Equity, and Multicultural Affairs, and we thank them for their kind and generous support. And I also wish to thank Professors Dawn Johnson, Kevin Brown, and Luis Fuentes-Rohr for their spearheading the important efforts to bring these events to campus. I think it's particularly appropriate that the first lecture in the Brown at 60 series is the Jerome Hall Lecture. Jerome Hall was a beloved faculty member who was a member of our law school from 1939 until 1970. He was a pioneer in the interdisciplinary analysis of legal problems, and his scholarship on the area of criminal law and jurisprudence was internationally recognized. Though he died in 1992, his work is still cited regularly today. Professor Hall's focus and his approach has a deep place in our institution's history. Our faculty continue to embrace Professor Hall's approach to work in their research and writing and through our Center for the Law, Society, and Culture. It's a belief that understanding how law develops and its impact on society and on culture is best understood through interdisciplinary analysis, and that we understand law better when we examine it through different lenses, situating law in its historic, economic, political, ethical, and social context. It's also the belief that a true culture of democracy requires an informed citizenry that is comfortable talking about and thinking about the law. Law, therefore, both reflects and defines our basic social values. The Hall Lecture seeks to honor that tradition by bringing influential and remarkable scholars to the Maurer School of Law each year. Recent lecturers have included Malcolm Freely from UC Berkeley School of Law, Rachel Moran from UCLA, Thomas Green from the University of Michigan, and Sanford Levinson of the University of Texas Law School. So today it's my distinct pleasure and honor to introduce Professor Mark Tushnet, the William Nelson Cromwell Professor of Law at Harvard Law School. Professor Tushnet has had a long and impressive career as one of the nation's most prolific, distinguished, and eminent scholars in a wide range of areas. He's been a member of the faculty of the University of Wisconsin, at the Georgetown University Law Center, and for almost the past decade, Harvard Law School. When Professor Tushnet became a chaired professor at Harvard Law, then Dean, now Justice Elena Kagan, called him one of the world's leading constitutional law scholars. His work is focused on constitutional and comparative constitutional law and legal history, and in particular, legal history of U.S. slavery and 20th century American legal history. To say that Professor Tushnet has had an impact on the way we think about some of the nation's most important constitutional law issues is, I think, an understatement. In addition to literally hundreds of law review articles, he has written 16 books and edited 8 others, including writing a 2-volume work on the life of Justice Thurgood Marshall and several books focused on the history of the Civil Rights Movement. He is also the co-author of 4 casebooks, including the most widely used casebook on constitutional law. He was the president of the Association of American Law Schools in 2003, and in 2002 he was elected a fellow of the American Academy of Arts and Sciences. Today's lecture is entitled Parents Involved and the Struggle for Historical Memory. It fits squarely into our Brown at 60 series because Parents Involved is a 2007 Supreme Court case placing constitutional limits on voluntary school desegregation. After the lecture, you're invited to join us for a reception upstairs in the faculty lounge. Please join me in warmly welcoming Professor Mark Tushnet.
Thank you, Dean Parrish, and I want to thank the law school for inviting me to give the Jerome Hall Lecture. I and to initiate this series of events over the legacy or in the aftermath of Brown. I want to begin by recounting something that happened at Harvard last year when we had an event honoring Justice Breyer on the 20th anniversary of his appointment. And the way we organized the event was that individual faculty members, maybe 10 of us, wrote short essays picking one of his opinions to take off from. And he was in attendance, and after each of us gave our little thing, he said something in response to what we'd said. And then at the end of the afternoon, he sort of was asked to reflect on the entire set of events. And the first thing he said was that he found it striking and interesting that none of us, this is true, none of us wrote about the opinion that he cared most about over his 20-year career, and that was his dissent in the parents-involved case. And that actually, I think, that observation about both what he regarded as the most important opinion and how the members of the Harvard faculty selected opinions to comment on, that has some bearing on my general theme about historical memory. And in my conclusion, I'm going to come back to this event and to the Breyer Tribute event and reflect a bit on the significance of both, again, our selection of opinions and his reaction to that. But before I get there, there's a fair amount of exposition about, as I put it in the title of the lecture, the struggle for historical memory in the parents-involved case. As you may know, the issue before the court in parents-involved was whether it was constitutionally permissible for a school district to use race as a basis for assigning public school children to schools for the purposes of achieving a greater degree of racial integration than would otherwise have occurred under, for example, a program assigning children to the schools nearest their homes. That was the issue. But as Chief Justice Roberts wrote in an opinion joined by 3 of his colleagues, and I will come back to the significance of the fact that it was a plurality opinion later, an important debate in the case was over which side is more faithful to the heritage of Brown versus Board of Education. The which side is more faithful is the Chief Justice's phrase. And that debate is part of what historians have called the struggle for historical memory. Contests among people today over the proper interpretation of events in the past. As one historian puts it, the word memory or heritage becomes a metaphor for the fashioning of narratives about the past when those with direct experience of events die off. This historian's writing of physical locations where such memories are fashioned. He continues, sites of memory are where local politics happen. Chief Justice Roberts' opinion in Parents Involved suggests that constitutional law is, again, metaphorically, the site of memory as well. What mattered was not the 14th Amendment, but the positions taken by the litigants who prevailed in Brown versus Board of Education. I'm going to talk about the politics of memory and Parents Involved after describing the memories of Brown offered by Chief Justice Roberts and Justices Stevens and Breyer, each of who wrote separate dissents. I'll turn to the local politics of memory and constitutional law. I'm going to argue that politics has 2 dimensions. One involving race, the other involving jurisprudence or judicial method. And I'll conclude with some speculations about the connections between those 2 dimensions. Now, according to Chief Justice Roberts, again quoting him, the position of the plaintiffs in Brown could not have been clearer. The 14th Amendment, this is an internal quotation, the 14th Amendment prevents states from according differential treatment to American children on the basis of their color or race. The programs at issue and parents involved, he's continued, were exactly that. They accord differential treatment on the basis of race. 2 children, one white, the other African American, were to be assigned to different schools solely because one was white and the other African American. Quoting the oral argument of Robert Carter, one of the NAACP's attorneys and later a federal judge, Carter said, "We have one fundamental contention, that no state has any authority under the Equal Protection Clause to use race as a factor in affording educational opportunities among its citizens. There is no ambiguity in that statement," the Chief Justice said. "The programs at issue and parents involved did determine admission to a public school on a racial basis," again, in his words. And quoting from the court's decision on remedy in Brown, the Chief Justice emphasized that the remedy was to achieve admission to the public schools on a non-racial basis, he emphasized that, and that the racial classification in these cases determine admission to a public school on a racial basis. Now, the lawyers, by then elderly, who participated in the Brown litigation immediately responded. Judge Carter said all that race was used for at that point in time was to deny equal opportunity to black people. It's to stand that argument on its head to use race the way they use it now. Jack Greenberg, another lawyer who worked on Brown and later headed the NAACP Legal Defense Fund, said that Chief Justice Roberts' interpretation of the plaintiff's position in Brown was preposterous. The plaintiffs were concerned, he said, with the marginalization and subjugation of black people. And William T. Coleman, Jr., another lawyer associated with the Brown litigation, called the opinion dirty pool and 100% wrong. Justice John Paul Stevens' dissent similarly drew on personal recollection in describing what he called the cruel irony of Chief Justice Roberts' reliance on Brown. After describing as more faithful to Brown an earlier decision in which the court had upheld the use of race to achieve integration, Justice Stevens ended, "It is my firm conviction that no member of the court that I joined in 1975 would have agreed with today's decision." Justice Breyer's dissent also sought to draw the lesson of history. The racial classifications used in the segregated South, he said, did not simply tell school children where they could and could not go to school based on the color of their skin. They perpetuated a caste system. And for Justice Breyer, it was, and again in his words, a cruel distortion of history to equate the plight of African Americans forced to attend segregated schools and whites forced to attend integrated ones. Brown did not merely articulate a rule, he said, but held out the promise of true racial equality, not as a matter of fine words on paper, but as a matter of everyday life in the nation's cities and schools. It sought one law, one nation, one people, not simply as a matter of legal principle, but in terms of how we actually live. Achieving integration, he continued, entailed complexities and difficulties, not least, one might infer, in developing legal doctrines suitable both for challenging segregation and promoting integration. But his concluding paragraph reverted to, again, in his terms, the promise of Brown, although somewhat clunkily, actually. This is what he says. The last half century has witnessed great strides towards racial equality, but we have not yet realized the promise of Brown. To invalidate the plans under review is to threaten the promise of Brown. The plurality's position, I fear, would break that promise. This is a decision that the court and the nation will come to regret. Now, I don't want to engage in a dispute over what Brown really meant, because doing so would be an intervention in the politics of memory rather than an effort to analyze that politics. One point, though, seems essential. Neither Chief Justice Roberts nor the dissenters were plainly wrong in what they extracted from Brown. Struggles over historical memory can take place only where both sides are contending over history, over what actually happened, to use the old phrase, and demonstrating that something never happened, or in the present context, demonstrating that either Chief Justice Roberts' view or the dissenter's view cannot plausibly be located in the relevant historical materials, converts a struggle over historical memory into something else, perhaps worth examining in its own right, but not a contest over history. Now, memory has many layers in parents involved. Most obvious are the claims from 2007 about what happened in 1954, but in 2007, Justice Stevens also asks us to remember 1975 when he joined the court, and then to remember what the justices sitting in 1975 remembered about 1954. The personal note is clear. He can remember 1975, and from those memories, he can remember 1954. And of course, countering Chief Justice Roberts' invocation of Robert Carter in 1954 is Robert Carter in 2007. And with the views of the handful of the still living participants of Brown, merely raises the question of historical memory. Should we privilege statements made today by participants in events a half century, now 60 years ago, over our own understanding of those events? The idea and memory and heritage is where local politics happens seems confirmed by the opinions and parents involved. Now, I said earlier that parents involved had both a racial dimension and a jurisprudential one, and I'm now going to turn to the jurisprudential one with some misgivings because it may be, in the end, this is a long detour. I don't think so, but if at some point you feel that I have wandered off, that you might be right. I mean, I'll be here, but the thread might have been lost. So an important theme in the development of modern conservative constitutional theory has been a strong preference for rules over standards. Rules produce consequences when a judge determines that a small number of criteria are satisfied, and those criteria are such that nearly everyone would agree that one was or was not satisfied. Standards, in contrast, require judges to exercise judgment about a larger number of criteria and, in exercising that judgment, decide whether a criterion is satisfied to a sufficient degree. So, for example, in parents involved, Chief Justice Roberts invoked the rule that policy that uses race as a criterion for decision is unconstitutional unless the policy is strongly justified by one of a small number of possible justifications. And determining whether a policy uses race as a criterion typically requires an almost entirely non-discretionary inspection of the policy's terms. In contrast, Justice Breyer would have applied a more standard-like approach in which a policy could be justified if it were designed and administered to achieve integration without imposing excessive burdens on school children. Now, nearly every term in that formulation requires the exercise of judgment. Is a race-based policy defended as designed to promote integration really so benignly motivated, or is it rather a guise for some less attractive goal? A particularly troublesome aspect of parents involved, as it happened, was the apparently nearly random administration of the policy, which shed some or cast some doubt over the claims about what the policy was actually trying to achieve. And of course, determining whether a policy places excessive burdens on someone expressly requires a discretionary judgment. Now, the contemporary preference for rules over, conservative preference for rules over standards is the product of history, not jurisprudence. A generation or two ago, constitutional conservatives defended balancing, a standard-like approach, against the more rule-like absolutism defended by liberals like William O. Douglas. And legal scholars have shown that as a matter of jurisprudence, there's no necessary connection between rules and conservatism or standards and liberalism. So why then did contemporary conservative constitutional jurisprudence come to assert a preference for rules over standards? And the answer is, again, rooted in history. The preference resulted from an essentially strategic choice about the best way to present to the public a larger framework within which criticisms of liberal Warren Court decisions fit. Such a framework was needed to provide the basis for arguing that conservatives were not merely disagreeing with some specific Warren Court decisions on simple political grounds, but had a larger constitutional vision within which those specific criticisms fit. Conservatives began with the judgment that criticism of liberal decisions as simply embodying the policy preferences of liberal justices was an effective way to package their own policy-based objections to those decisions. For conservatives, the liberals' living constitution was liberal policy dressed up in constitutional interpretation. The conservative alternative was to present the conservative way of doing constitutional law as one that avoids making policy decisions. To use Chief Justice Roberts' now famous metaphor, as simply calling balls and strikes. Now, conservative constitutional jurisprudence came up with two methods of denying that today's justices make policy decisions. One was to locate policymaking in the past by means of some sort of originalist constitutional interpretation. Constitutional law did require policy making, but the relevant decisions had already been made, and the judge's only job was to determine what those decisions were. The other was to use rules. The other way of denying that today's justices are making policy decisions was to use rules rather than standards. It's worth noting, I think, that originalism and rules-based decision-making are alternatives that need not always point to the same result. It's striking, for example, that originalism plays no overt role in Chief Justice Roberts' opinion in Parents Involved. The historical references are not to 1868 or any time, they're to 1954. Longer version of this, I could say, well, maybe originalism plays a role, that somehow Brown was reconcilable with an original understanding. For a variety of reasons, I think conservatives have sometimes taken that line, but for a variety of reasons, I think it doesn't work. But that would be even more of a detour, so I will return to this detour now. Originalism and rules-based decision-making are justified within conservative constitutional jurisprudence as methods that constrain judges and eliminate discretionary and policy-based in constitutional interpretation. I now want to say a few words about the liberal response to the conservative critique of judicial judgment. If the association between rules and conservatism is merely contingent, why have liberals fought to preserve judgments, standards, balancing, and the like, rather than offering their own set of rules as alternatives? Doing so, you might think, might be politically effective in countering the conservative charge that rules are all that keep judges from enacting their policy preferences into constitutional law. Liberal rules would show that the rules offered by conservatives are no less policy-based than the Warren Court's decisions. And here, too, there's a note to be added about how liberals, to some extent, have joined with conservatives on rule-based adjudication in First Amendment cases, but not in the race cases. Now, I want to suggest a couple of reasons for the liberal commitment to standards rather than rules. The first is suggested by one strand in the liberal response to the originalist element in contemporary conservative jurisprudence. Occasionally, liberals have taken originalism on, attempting to show that the conservative claims about original understandings, meanings, or whatever are no more strongly founded than liberal claims. And so that the decisions today's conservatives assert were made by the Constitution's authors are actually being made by today's conservative justices. I suppose the fanciest version of this liberal response is embodied in Jack Balkin's book, Living Originalism, where you can see the effort to combine the living Constitution with the conservative originalism idea. Now, the most effective liberal version of this argument has been made in connection with the very issue in Parents Involved. the constitutional permissibility of race-based decision-making aimed at improving the conditions of life for African Americans, and more broadly in connection with Brown. Liberals have shown, at least to their own satisfaction, that legislatively adopted affirmative action programs are entirely consistent with the original understanding of the 14th Amendment, and that a constitutional rule banning school segregation is not consistent with that understanding. So affirmative action is okay under the original understanding, and Brown is not okay under the original understanding. Again, there are complicated arguments here that need to be unpacked, but that's the bottom line of the liberal position. The problem is, though, that liberal originalism, or living originalism as a critique of conservative originalism, hasn't made much headway in undermining the conservative claims about originalism as a non-discretionary method. The reason, I think, is that everyone, liberals and conservatives alike, knows that the liberal commitment to originalism is merely strategic. In contrast, conservatives were able to present their commitment to originalism as principled, although, again, when you examine how they deploy originalism, you observe a fair amount of strategic decision-making within the within a general framework of originalism. Put another way, the historical conditions, whatever they might be, for a liberal originalism have not yet presented themselves in the way that the conditions for conservative originalism did present themselves. A slightly different way of making the same point is to observe that liberals are half-hearted about originalism, whereas conservatives are committed to it, where, again, it is a very complicated thing, full bore. We can be pretty confident in predicting the outcome of a conflict between half-hearted and full-bore originalism. The second reason that liberals haven't offered their own counter rules is this. 2 generations ago, or when Brown was decided, liberals might have defended the rule that state laws that expressly relied on racial classifications to disadvantage African Americans were unconstitutional in the absence of exceedingly strong justifications, but that state laws expressly relying on such classifications to benefit African Americans were constitutionally permissible, again, except in extreme cases. When Brown was decided, and for a while thereafter, the need to articulate such a rule, again, a liberal distinction between, I guess, what we would now call benign and malign discrimination expressly using race, the need to articulate such a rule didn't present itself because there were no state laws in the latter category, which is one reason that both sides and parents involved can claim the heritage of Brown. By 2007, precedent on affirmative action had accumulated to the point where a simple pro-affirmative action rule wasn't plausibly available. The court had ruled out rectification of societal discrimination as a ground for affirmative action, for example. And any liberal defense of affirmative action that respected precedent had to accept that limitation. The effect was to drive liberals in the direction of standards rather than rules as a way of indirectly getting into constitutional law considerations that precedent made it difficult to embody in rules. I think it worth noting as well that white liberals and some African American liberals were uncomfortable with race-based classifications as such from quite early on. Nervousness about quotas ran deep nearly from the beginning, particularly among liberal Jews who remembered, and some of whom had experienced the use of quotas, especially to limit the opportunities of Jews in higher education. I have an anecdote from my father's application to medical school in 1929, where he was excluded from Columbia Medical School because he was Jewish. He was told that was the reason that he was excluded. So liberals, therefore, would have had a principal difficulty in articulating a rule authorizing the use of race in public decision-making in some circumstances or for some purposes. Now, parents involved fits into the contemporary jurisprudence of rules, but that in itself wouldn't account for the struggle within the decision over Brown's meaning. And now I turn to the racial dimension of contemporary conservatism. The standard account of that dimension focuses on the Republican Southern strategy, which aimed at achieving national political dominance by capturing the votes of Southern and Northern whites by focusing on their perceived displacement in politics and the economy resulting from Democrats' commitment to racial equality. That account needs to have some modification, and it's begun to receive it as an overall account of political developments in the late 20th century, but I'm pretty sure it's going to remain at the core of the account of the development of conservative constitutional thought. For all practical purposes, the Warren Court decisions that became the heart of the conservative critique were either directly concerned with race, such as decisions dealing with transportation remedies for violations of the non-segregation rule, or had strong racial overtones, such as the Warren Court's decisions on criminal procedure, which for liberals were responses to the racially biased administration of justice, and for conservatives were important causes of the increases in crime the nation experienced. Now, the Southern strategy and its implication for conservative constitutional thought about race provide a decent explanation for the outcome supported by Chief Justice Roberts. Voluntarily adopted by a political majority in the city, Seattle's integration program nonetheless placed the same kinds of burden on some children as had the court-ordered busing remedies. Now, conservative constitutional thought initially focused on the court-ordered part of that, but it was motivated by means of the Southern strategy and the like. It was motivated by the burdens. And so once presented with a case involving only the burdens and not court ordering, the background motivation was what was captured by the rule. But that doesn't explain why Chief Justice Roberts thought it important to claim the heritage of Brown for his position. The answer has to be that Brown has become what people have called a fixed point in contemporary constitutional thought generally, not liberal or conservative. No version of constitutional law or theory is acceptable if it casts doubt on Brown's correctness. The other side of the coin is that any version of constitutional law and theory gains some credibility if it can claim Brown's authority. The politics of memory in parents involved is not thus a struggle simply over what Brown meant, but more important over the merits of contending positions in today's constitutional law. It would count as a reason against the outcome in parents involved that Robert Carter's argument in Brown was inconsistent with that outcome, and as a reason in favor of the outcome that Carter's argument was consistent with it. And for the politics of memory to work, there must be no ambiguity, again quoting the Chief Justice, about what Carter argued. For, as I've suggested, ambiguity about his argument, Carter's argument, would make it plain that the discussion is not about what Carter said in 1954, but about what today's justices should do. To the extent that parents involved is about the heritage of Brown, though, one must notice one jarring note in Chief Justice Roberts' presentation. The figure most associated with Brown is not Robert Carter, but Thurgood Marshall, who doesn't play an overt role in the Chief Justice's opinion. Now, part of the reason is rhetorical and artifactual. Marshall argued Briggs versus Elliott, the South Carolina desegregation case that was decided along with Brown. At the time, people generally understood Briggs to be the more important case because it came not from the border state of Kansas, but from the heartland of Jim Crow in South Carolina. And the relative significance of the two cases is shown by who argued them. Marshall argued for the plaintiff's challengers in Briggs, and the state argument was offered by John W. Davis, former Solicitor General and presidential candidate. In Brown Board of Education, the Supreme Court had to ask Kansas's Attorney General whether he intended to present argument in Brown. And the Attorney General dispatched a young lawyer named Paul Wilson, an assistant attorney general who had never argued a case in any appellate court, to do so. Wilson's memoir of this is quite engaging, actually, about how he had to buy a suit. So Chief Justice Roberts constructed his opinion around Brown, which allowed him to quote Carter and not Marshall. Yet, I have to say, had he so desired, the Chief Justice could readily have extracted quotations from Marshall's oral presentation in Briggs to the same effect as Carter's. Why then use Carter rather than Marshall as the vehicle for articulating the Chief Justice's rule? I suggest that here, too, the reason implicates memory, both personal and historical. 4 members of the court in 2007 had served with Marshall. And one, Justice Anthony Kennedy, provided the 5th vote to overturn Seattle's program. These justices knew Marshall in a way that they did not know Robert Carter, and they knew insofar as anyone could know what Marshall would have thought about the constitutionality of Seattle's program. He had written enough opinions dealing with the related issue of voluntary affirmative action programs to make it clear that he would have found Seattle's program constitutionally permissible and in his more expansive moments, perhaps even constitutionally required, claiming Marshall's authority for the result in parents involved, even if it could have been done with the same kind of evidence from the oral argument that the Chief Justice used, and it could have been, would have been an insult to Marshall's memory, in a way that using Carter's words, were not quite insulting to Marshall, as indeed the criticisms of Greenberg and Coleman, the dirty pool line in particular, suggests, and for that reason would have weakened the Chief Justice's opinion. The struggle to claim Brown heritage does raise a final question. As I've suggested, the Chief Justice treats Brown as the foundation for the rule he applies. Brown, not the 14th Amendment. Looking backward, we see Brown with the 14th Amendment obscured behind it. What that means, though, is that the Constitution is indeed a living document. A decision made more than 80 years after the 14th Amendment became law is the source of the constitutional law we apply today. The living Constitution aspect of parents involved is made even clearer by the Chief Justice's references to the briefs and oral argument Brown, and it's made clearer still by the authority the Chief Justice seeks to gain by claiming the heritage of Brown. Those who wrote the briefs and presented the oral argument in Brown become as authoritative as, perhaps even more authoritative than, those who adopted the 14th Amendment. Now, parents involved reveal some tension between the two components of contemporary conservative constitutional thought. Its orientations to rules produces an opinion that is best understood as embodying a living Constitution view rather than as originalist. Seeing law as a site for struggles over historical memory, we shouldn't be surprised at discovering such a tension. Such struggles are conducted today with an eye to the past, and contemporary audiences are unlikely to have the kinds of fully coherent ideologies favored by political theorists. The local politics of a struggle over historical memory then will almost inevitably reflect tensions and incoherences. Finally, what of the future of Brown in legal memory? I'd initially thought that there was a difference between struggles for historical memory conducted in the law and those conducted, for example, in discourse about museums and the inscriptions to be placed on memorial structures. The law, I thought, had an institutional structure, in particular a commitment to precedent that would provide a distinctive shape to struggles for historical memory. So, for example, the next time we find it important to fight over Brown's meaning in some legal context, we'll have to take account of the meaning given Brown by parents involved. That is, we'll have to take account of parents involved as a precedent. We have a repertoire of techniques for doing so, including disregard of the Chief Justice's use of Brown as wrong the day it was decided, as the court put it in overruling Bowers versus Hardwick, or we might set aside the meaning given Brown in the Chief Justice's opinion because it was merely the meaning given by a plurality of the court. Justice Kennedy concurred in the result, but didn't join the part of the Chief Justice's opinion dealing with Brown. And indeed, Justice Kennedy's dispositive opinion can be given quite a narrow reading. As I mentioned, that Seattle's program was unconstitutional because it was administered in such an incoherent way as to cast doubt on the claim that the city actually had a program reasonably aimed at achieving integration in the city school. Now, the need to deal with precedent, I had initially thought, distinguished struggles for historical memory and law from those in other sites. On reflection, though, I think that institutional difference may be less significant than I initially thought. For in the local politics of historical memory, real history has its claims. That is, how a community has dealt with an issue in the past matters in the discourse it uses about some contemporary question. Sometimes, for example, the issue is replacing one historical inscription on a memorial with another. The mere fact that there had been an earlier inscription carries some weight in the discussion of what to do today, in the same way that a precedent carries some weight in the law. Even erecting a new monument brings to the fore the fact that the community had previously decided, at least implicitly, not to memorialize something. And the community will have to decide whether the reasons for its neglect remain good ones or are overridden by other considerations. So law, as understood as a site for struggles over historical memory, may not be that different from the other institutional locations where such struggles occur, except perhaps for having an institutional struggle that brings to the fore matters that are addressed only indirectly in other discourses. Now, the Supreme Court can't definitively determine Brown's meaning because politics, the local politics of historical memory conducted in law, cannot provide anything more than a temporary resolution of the differences among us. But it's important to emphasize the next time a struggle over Brown's meaning occurs in the law, it's not going to occur in connection with an effort to integrate the schools. History moves on. Brown will matter if it does because we will come to think that it has some bearing on a political issue that agitates us at the moment. And no one can tell what that issue will be. But we can be sure the meaning given Brown by the Chief Justice and parents involved will be no more than one of many items of discourse when once again we struggle over Brown's meaning. And I now just want to conclude by returning to the event involving Justice Breyer, because my presentation is predicated on the view that there will be a continuing struggle over the meaning of Brown. But what Justice Breyer's observation suggests is that while Brown was and is for his generation vibrant, central to the understanding of constitutional law, that centrality of Brown may have, I'll put this a little strongly, completely dissipated for contemporary generations of scholars and students. And so it may be that the struggle for historical memory in Brown is now a historical episode, not an ongoing event, as it was for the court in 2007. I will say, I think that would be quite regrettable because for me, understanding the Constitution as a whole means understanding the role of race in the Constitution then and now and almost certainly into the indefinite future. But I have to say, I was a participant in that event, and it didn't occur to me to observe how odd it was that none of us mentioned parents involved. Thank you. I'm happy to take questions. Yeah, so I'm happy to take questions. Yeah.
Well, let me put it in a school desegregation context, not actually a legal context, but 4 years from now will be in 2018, which will be the 50th anniversary of Green versus New King County. And that then comes back to how one interprets.
And the 100th anniversary of the 14th Amendment, which is where I thought you were going.
Okay, but it then comes back to the interpretation of Brown, because if you see Brown the way Roberts does, now Green versus New King County becomes a reach by the court far beyond what was necessary to resolve the segregation cases. So are we going to have a conversation during the 50th anniversary of Green that basically says the Supreme Court, when it ordered desegregation, went way too far?
I think the answer is almost certainly yes. One way that will occur is through Justice Brennan's very powerful line in Green that says the point is not to have black schools or white schools, but just schools. And now we will see in 4 years the ambiguity of the word just there. So merely schools or schools that achieve justice. I'm confident, I don't know this, I haven't tracked anything down, but I'm reasonably confident that Justice Brennan was self-conscious about the ambiguity of that word. But, I can see the symposium title already, Just Schools, Green versus New King County after 50 years, right?
Do you think the idea of just schools and the idea of Brown is what would that show about the recent ruling in Hewitt about removing any policies of affirmative action, or what are your thoughts on that?
Yeah. So I think my own take on this is that the way this is just who I am and where I am in the constitutional spectrum. The way to think about all of the questions is with respect to the centrality of race in U.S. constitutional history and as I would put it, the constitutional imperative of doing everything possible to minimize the ongoing significance of race. So although Justice Breyer concurred in Hewitt, if that's how you pronounce it, I don't know, but I think it's a given the role of race, it's wrong. Is that responsive? I'm not sure.
When Brown also, when Brown's just schools, does that show if someone has some state argues that there's no more signs of any issue with race, so we can remove any of these policies of protection, and that would just if they found them all in the way.
Yeah, and so I think the answer is no. That would be, an unreasonable judgment. I actually, to the extent that we apply mere rationality, if that were the state's defense, which it isn't in the Michigan case, it would not be a rational defense. There was another. Sorry, yes.
You talked about how Justice Marshall did Briggs and Carter did Brown. Why, if Briggs was, such a not higher contempt, but it had more, Justice Marshall and Attorney General there, why do we not discuss that more in Brown versus Board of Education? Why is Brown to the forefront?
Because it's the name of it's right there on top. There's some I don't know what there's some lore about why the case is Brown rather than Briggs. The lore, which is mistaken, is that the justices chose a Kansas case rather than a Deep South case as a way of attempting to avoid inflaming even more than they thought it would public sentiment. The reason Brown comes first is that it got to the court like 2 days before Briggs. So its number was the lower of the numbers. That's the only reason. Yes?
Is it essential that a decision to have historical memory be sort of a consensus, paradigmatic, great decision that is accepted now by both sides as being fundamental to the constitutional canon? Could it either be a dissent? I mean, you've got Plessy versus Ferguson, the Harlan dissent, and it has conflicting meanings in it too, where he talks in part about a colorblind constitution and talk in part about there is no caste here. You can pick up on either one of those themes and do something with it. You've got the dissents in First Amendment context from Holmes and Brandeis, but I take it you would not have a debate of the same nature about, for example, what Roe versus Wade really meant. Would you, or would you? Would you have arguments sort of attempting to vindicate Roe versus Wade in terms of what it meant to those who argued the case, or perhaps to Justice Blackmun who wrote the opinion? Or is that not likely to occur when you have so much dissensus about the validity of that precedent?
Yeah, so that I want to think some more about it. I think as a sort of, I hate to say this, as an analytic historical matter, one can imagine sort of a conservative reconstruction of Roe that would say what was really going on there was something. I don't know what it would be like. But as an analytic matter, I think you could do it. But I think the idea that it's much easier to conduct struggles over historical memory when everybody agrees that the site is the important location for the struggle. So again, think of monuments. Some monuments attract attention, others don't. You could gin up a controversy over virtually any monument or inscription, or as we're now experiencing, naming of buildings on university campuses. But it's only when lots of people agree that this thing carries important symbolic weight that you're going to have the struggle for what this thing's meaning is. So yeah, to some extent, I think consensus does matter. Now, I think you could have consensus over dissents, canonical dissents, like, and indeed, I think the Chief Justice could have written parents involved centering on Harlan's opinion in Plessy and Ferguson. He made a strategic decision to focus on the NAACP's arguments in Brown.
Well, perhaps you could join me in thanking